Our next speaker will be talking about some of the common problems those of you who have corporate clients have to address. Constance Olsheski received her Bachelor of Law degree from Osgoode Hall Law School, as well as her MBA from York University in 1982. She began her career with Strathy, Archibald, and Seagram as it then was, and then leaving law for a short time, became vice president of Cineplex Odeon Corporation, and is now managing associate at Howard Levitt and Associates. Her past in sports and entertainment has resulted in the publication of two works, one entitled Hockey, It's Your Game, and the second, Pantages Theatre, Rebirth of a Landmark. She also co-produced several television programs on the subject of hockey and appeared on both radio and television when the Pantages Theatre returned to the Toronto theatre scene. Now, happily, she's focused on employment law and is co-editor of the Dismissal and Employment Law Digest, providing monthly summaries and evaluations of the law relating to dismissal across Canada.
Well, all day we've had the luxury of listening to analysis on academic analysis on the evolution of the law, but those of us who practice with employment law recognize that there are some very basic practical issues that face us all the time. I'm going to be dealing with two of these this morning, although I dealt with three of those in my paper. And for those of you that deal with the down and dirty, then please do refer to the paper because it may be helpful. The first issue I'm going to deal with is the disruptive and the incompatible employee. And the second is absenteeism, given the time that we have. I'm going to try to define when enough is enough. So if you represent an employer who claims to have tolerated enough of a particular employee's challenge of his authority, or the incessant complaining, or language that's simply out of place, you have to advise him how much of that has to be tolerated. Or if you represent an employee who has taken the liberty to advise the employer just exactly how he or she feels about him, and has advised the employer exactly how the company should be run, and none of it has gone over very well, the following may be helpful. The general rule is that a personality conflict, standing alone, will not constitute cause for dismissal. Obviously, hopefully, as a result of today, you'll note that corporate fit is not an objective test of one's performance, and then cannot be seen as a breach of the employment contract. Employers, therefore, seek to shield their decisions by camouflaging it on another cause for dismissal. Courts are wary of that and frequently will challenge the alleged cause. Personality conflict, unaccompanied by misconduct, is not cause for discharge, even if it affects office morale, or if it antagonizes key customers and those customers indicate that they will take their business elsewhere if the employee is not terminated. Neither is a difference of an opinion with a superior found to be cause for discharge. Mr. Armstrong, out in New Brunswick, was a general manager with Atlantic Traders. He had extremely difficult interpersonal relations with his employees and his suppliers. And he was finally discharged when he had a major disagreement with the president of the company. When he sued for wrongful dismissal, the court found that, yes, he was extremely aggressive in his business practices, but it didn't constitute cause. Ms. Clark was a private school teacher at St. Margaret's School. She refused a salary reduction, and since the board wasn't accommodating her, she went above the board and wrote to all the parents of the private school indicating her displeasure. The court found, after she was terminated, that the defendant did not prove that she had prejudiced the school's business. Her counsel was astute enough to have argued that the teacher regarded the parents as her true employer. And the court, for some reason, accepted that argument and found that it was a personality conflict, but there was no cause. A salesman, Mr. Squires, in Nova Scotia, was displeased because his department failed to win a sales contest. He was so upset, he sent a memo to management berating them, telling them how they really should run the company. And despite the fact that he had gotten previous good employee reviews, management terminated him based on his past alleged shortcomings. The court found, sorry, this is only a personality conflict, no cause is found. So the very difficult question facing you when you're advising employers is, what tolerance is expected by the courts, and how can you dismiss an employee who's disruptive and incompatible without incurring the liability of severance or a legal action? Courts, however, do have some sympathy in this regard and attempt to find cause by pinning it on another head. So to the degree that it can be found that such behavior will constitute insubordination, dishonesty, disobedience, abusive behavior, or a revelation of character, of an untrustworthy character, then cause will be found. However, in finding cause under these subcategories, the onus will be on the employer to prove it, and the onus will be a very high one. Just to discuss disobedience for a moment. If the personality conflict flows from an employee's disobedience, cause may be found to exist because it's based on real misconduct. Mr. Woolley was a one-year employee who displayed an abusive personality. He didn't follow company rules. He alienated subordinate employees. He failed to report to his superiors on a timely basis. He didn't properly service his customers, and he didn't hold sales meetings as they were required. Not the most admirable employee. The court held that in and of itself, personality conflicts between the employee and other staff members didn't constitute grounds. However, they found cause was substantiated because of his disobedience to follow his superiors' orders, which was to conduct weekly sales meetings and to report to them. A manager of a company which harvested peat moss sold damaged bales to the public, contrary to the company's policy. The company's policy was that you could personally use the damaged peat moss to whatever degree you would, but he instead sold it to the public. He deposited the monies into an account called the drink fund for the employees. The employer found out about it and terminated him. The court found that the employer was justified in terminating the employee on the basis of disobedience, because the manager should have realized that it was only a verbal directive, must be followed. However, the court also came to this conclusion, perhaps on the basis of the fact that not all of the sales proceeds from the drink fund were accounted for. If an employee is disruptive because of a personality conflict, this is distinguished in law from an employee who reveals a character trait that is unworkable and untenable for the continuation of his employment contract. The courts recognize that this latter type of employee can be discharged as the employer can no longer reasonably trust him. But it places upon the employer the onus to prove that the plaintiff has revealed aspects of his character which were incompatible with his employment contract. The Supreme Court of Canada has stated that where an employee reveals an unsavory character or a character inconsistent with his discharge, it is not so much the conduct itself, but it's that his character is capable of such conduct which justifies the dismissal. However, as has been reiterated several times today, courts now look at the revelation of character in the context of the employment. In Prince Edward Island, a store manager was terminated because he breached his own company policy, which was you don't shop in the store after store hours. The court found that although he did shop in the store after it was closed, this may have set a very poor example to his employees that he was to be managing, and it may reveal poor judgment on his part, but this wasn't an incident that revealed an untrustworthy character. However, a Ms. Anderson, who worked for Pioneer Sports World as a marketing and promotions manager, obtained tickets for a holiday in exchange for purchasing advertising on a radio. Instead of recognizing that such tickets would be company property, she personally used and enjoyed them. Once the employer, of course, found out, it terminated her. The courts found that this was a revelation of character, and she was justly dismissed. If an employee engages in abusive behavior, obviously, and which results in assault charges being found, then cause will be supported. One employee's relationship with others deteriorated to the point where he indicated to the employer that either he goes or I go. The company terminated him for such behavior, and the courts found that in a 3-employee plant where he worked, his termination was justified because of the impact of his conduct on the company's operations in total. Mr. Bell was an advertising manager with General Motors for 21 years. He became romantically involved with one of the secretaries in his office. He was verbally abusive to her in the workplace, but privately he took that a little bit further and assaulted her. She laid charges and he threatened to kill her. He was dismissed, and the courts found that certainly and obviously it was a manner unbecoming of a member of management. But more importantly, for our purposes, it revealed an aspect of his character which could lead General Motors and any employer to conclude that his continued employment would be bad for employee morale and could lead to a risk of further disruptions. Recent cases, however, in the discussion of the judges this morning would suggest that there's a little bit more of a liberal approach in allowing a company to dismiss an employee who simply is disruptive and incompatible, regardless of the assault or the dishonesty or the fraud. Then, if the behavior is simply disruptive with the tone of the office, the effect of the company will be assessed, and cause may or may not be supported, depending on the context in which the behavior occurred. Courts, in these cases, have allowed the employer to argue successfully the cumulative effect of the employee's behavior. Previously, if this kind of behavior wasn't responded to, and if there was an accumulating event, then no cause would have been justified. But now, cases suggest that it is. An employee's personality is demonstrated then through his behavior. If it prejudices the employer or is incompatible with his employment, will constitute cause. However, in order to establish this, the company must provide specific examples of harm to the business occasioned by the employee's misbehavior, and must warn the employee that his or her job is in jeopardy unless the conduct improves. A controller who was with the company for 10 years had consistently orally abused his subordinates. The court found that, however, the company had condoned this behavior, as reflected by the increase in salary that had been given through him over the years. In addition, though, because there was no precipitating event or culminating event in the last year of his employment, the company was stopped from relying on this as grounds for dismissal. Another employee, a senior employee, was late for work in the mornings over a period of years, and after several warnings, he was dismissed. The court held that the conduct of the plaintiff must be considered as a willful act of disobedience, not only to the lawful and reasonable, but also to the necessary orders of the defendant. Therefore, where punctuality is an important element of the employment contract, then failure to honor it could constitute cause for discharge. In another case, a trial conducted by my friend Mr. Levitt, an employee was, and Mr. Levitt may expound on this a bit later, extremely incompatible and disruptive. So much so that it led to 3 grievances against him in his particular department. and I believe it's in a company which had a very low history of grievances. The court found that although most of the occurrences occurred over his whole working time, they were not sufficient to warrant dismissal for cause, but together with his overall conduct, his abusiveness, they were serious enough. Would you like to just further comment on that case, if I've missed anything important?
I think that's
Okay.
some good summary.
In another case, an employee consistently berated his fellow employees. The court found that it was reasonable for the employer, who was seeking to improve employee relations, to require an apology from the employee, who, when it wasn't forthcoming, was entitled to terminate him. In Alessa and Dave Buck Ford, which is a car dealership in Vancouver, Mr. Alessa, although he was car and truck fleet sales manager for a few months of his 17 years, he continued to call himself sales manager. And the company repeatedly requested that he terminate and cease giving himself this loftier title than he actually had. Mr. Buck died, and Mrs. Buck finally took over the business. And although Mr. Buck had been extremely tolerant of this particular employee, Mrs. Buck was less so. The employee, in addition, drove a demonstration vehicle, and it was to make it available for display and demonstration, but left it at home because he was within walking distance to the office or to the dealership. In addition, he, instead of obtaining approvals for various sales before the closing, he got them afterwards. On one final sales offer that he presented to some rental company, Mrs. Buck noticed that he had attached his old sales business card, which stated sales manager. She frustratedly terminated him on the spot. None of these events, the court found, in and of itself would have constituted cause for discharge, but collectively they were sufficient. Justice Hollingray of that court in the British Columbia rejected the argument that because these lesser acts of disobedience occurred over a period of time, they were condoned by the defendant, and instead supported the employer's efforts to deal with the employee by stating, "I do not think that the law does or should discourage employers from trying to work out difficult situations with employees, and this is especially so with long-term employees." Hopefully that's clear as to how an employer can deal with a disruptive or incompatible employee. However, the question remains, is a warning required? The law, unfortunately, is not definitive as to whether or not a warning is required to terminate a disruptive employee. Given the subjectivity of terminating an incompatible or disruptive employee, a warning is advised. In Rogers and Canadian Acceptance Corporation, Justice Bursell stated that the reluctance of the courts to regard such conduct as cause for dismissal would appear to find its origin in the inherent difficulties in setting an objective standard. The warning, thus, would have provided the plaintiff with, at the very least, knowledge of the test that the employer intended to use to assess his competence. However, there are several cases which indicate that a warning is not required. If the employee should know from the circumstances, including his record or reprimands, that his job is in jeopardy if his performance does not improve, then a warning is not required. In the instance in which Howard argued the case that I mentioned earlier, Fonkeka, no warning was given, as I recall, except that the court found that because the grievances had been held, this was sufficient. This should have constituted a sufficient understanding on his part that his performance was unacceptable. However, Mrs. Justice Finlayson this morning introduced, for the first time, for me anyway, the concept of the reasonable employee. And therefore, the determination will be probably made in the context of the corporate culture and the behavior of the employee himself. Do I have time to just enter absenteeism? Another extremely common problem faced by us in this area, absenteeism. It's the billion-dollar loss to Canadian companies and to the Canadian economy. Each minute lost to a lack of punctuality constitute the pennies. The lateness due to the car that doesn't start is the loonies. And the days absent due to the flu or the cold, when added to the pennies and the loonies, soon add up to the billions. Although the employers know the cost, few know the resolution. They frequently query, to what degree does this absenteeism have to be tolerated? The law is very clear, and you should be able to counsel them rather easily on that. Absenteeism without a legitimate justification can justify the termination of the employee. However, if, I think I just have to quickly summarize this because 5 minutes isn't going to do justice to it. However, if absenteeism, if one wants to discharge an employee because of absenteeism, it's easier to find cause if we can label it on another head. So for instance, fraud or deceit. If an employee claims to be absent because of sickness, and in essence he or she went down to have Madonna sign her recent biography or latest book, then, and a sickness wasn't justified, wasn't the absolute reason for the absenteeism or the absence, then cause can be justified on the basis of that deceit or that fraud. However, illness in most instances will be a legitimate excuse. It will not be a legitimate excuse if it's a cold or something that's not contagious and won't affect either the employee's performance or any other employee's performance. And an employer can insist that an employee come to work. However, if that employee deems to stay away because he or she is unfit to come to work, an employer can only seek cause in that instance if the employee has failed to honor the company policy, which is to provide a medical certificate for each such absence. And if the company policy exists but it's not adhered to, it will be useless to come to the defense if sued for wrongful dismissal. As noted earlier this morning, absenteeism can in and of itself justify dismissal if it does harm to an employer's business. Mr. Justice Finlayson mentioned the case where punctuality resulted in an interruption in the production line. One has to be careful when counseling employers to note that if they fail to respond to an employee who is absent, it could be found to be tolerance and condonation of that employee's activity. And on a final note, it's not necessary that an employer treat all employees equally. If a specific employee seems to be excessively absent, more stringent policies and practices can be applied to that particular employee. Howard, I noticed the clock's ticking.
No, that's great. In terms of questions though, because you weren't able to deal with everything, why don't we take any questions that people have relating not only to what Constance actually spoke about, but any other, for that matter, common human resource problems that are human resource problems from a corporation standpoint that you might wonder about. How do you deal with a particular problem in the workplace? Yes.
Key employee is disabled, not permanent, but requiring surgery and possibly being off work for a year. That key employee, i.e. executive director, is subsequently replaced by the board of directors, basically being told that you're being terminated now, and here's your severance package, which may not be all that evident. In a situation like that, are there
I want to caution one thing, and it's in my paper on disability. Many employers, and many lawyers, I believe, as well, are under the impression that if an employee is disabled for an extended period of time, and let's call that long-term disability, then that frustrates the employment contract based on the law of contracts. That's not necessarily correct because of the definition of what is long-term disability. And the courts have not defined that. And they have said that a 2 and a 3 year long-term disability is not sufficient to justify dismissal. So I just want to caution you on that part. So in the context that you raised, and I hope everyone heard the question, or else this is kind of only benefit to one person, but the employer, if he terminates someone while on disability, be it short-term or long-term, will have been found to have wrongfully terminated that employee. Not only that, but the employer will be responsible for the wages for the employee during that illness, if it is the company policy to pay for illness, and that the severance will only run when the employee is capable of returning to work.
McKay and Camco of the Ontario Court of Appeal. McKay versus Camco. Mr. Justice Finlayson, in fact, wrote the dissent, but a fairly strong dissenting opinion, but that's the majority opinion.
Also, if I can make one other point, because it's quite important. If you terminate an employee, and the employee becomes disabled after you've terminated him, you should be cautioned that it's the employer's responsibility, potentially, to be responsible for those long-term disability payments for as long as they continue. And if for some reason the employer has terminated its contractual obligations with the insurance company, the employer will be responsible.
And that is the nightmare scenario facing a corporation. If you terminate someone who potentially let's assume they're ill at the time, you potentially face the risk of them becoming disabled during a period of reasonable notice, and perhaps the nature of the disability is such they'll be disabled for many, many years, ultimately passing away, so that you're responsible for LTD payments, if they would have commenced during the period of reasonable notice, for many years, and then depending upon the particular benefit policies of the company, you may be responsible for the life insurance premiums, if that would have attached. So it could be more than $1 million award, whereas simply continuing benefits for a period of reasonable notice and salary wouldn't have cost very much at all in a particular context. That you have to be wary of. So when you're going to terminate or give advice as to the termination of an employee who's ill and either may die or may become disabled during the period of notice, do what you can to maintain benefits. Again, a caveat to that is many insurance companies will not continue ADD or LTD for someone who's been terminated. But generally that can be worked out.
I think this gentleman.
How would that apply if you had made your payments, your severance payment, to the employee based on salary plus a percentage, whatever the percentage rate of benefits
And
is applicable? If you had made that payment, say a 12-month payment, including 17% or 20% benefits.
Well, obviously, if you're paying it, and if you're counseling, no, but if you're counseling an employer, you're not just going to pay that without obtaining a release. And so hopefully that would be covered by the release. Yes?
How do you counsel an employer who calls up and says they've got one of these disruptive or incompatible employees in terms of setting up the circumstances to say, we've got 4 months from now, we've got this person's review, it's a nagging problem with our company, but we don't think that there's any money that we can point to that will allow us to dismiss them for cause. In terms of type of advice, keep track of the problems. And that's to take demos, or do you have to sit down with the person, point out to them, as you said, with this warning situation? Is it enough to just keep track of the instances and present them all at once the day that you fire the person?
Well, generally, a disruptive employee, it's my experience, having come through the business ranks as well, is a disruptive employee. and you can provide warnings and identify the standard that has to be met, and it's still going to continue. So I think if I were in your position and advising an employer, I certainly would indicate that a warning be given. And indeed, although I've identified case law that seems to suggest that it's not absolutely necessary, of course, you would seek to protect your client as much as possible. However, Howard was in a case where a warning, I believe, was not provided, so maybe you'd just like to comment on
Well,
that.
the McDonnell-Douglas decision that Constance is referring to found that it should have been obvious to the employee that his job was in jeopardy, and therefore no specific warning was required because the nature of the incidents that led to the termination, the group union grievances and the rebuke he experienced, plaintiff experienced from senior management, was so unusual that he had to have known his job was in trouble.
That sounds somewhat more extreme. I'm thinking of the less obvious case of the person who did the bad seed that you hear about a lot from employers, and they just want to get rid of that person, but they're concerned about maybe the fact that the person's been there 10 or 15 years, they're going to be faced with a substantial severance.
Well, if I could just
Yeah.
go on a little bit about that, I guess there's three scenarios. First of all, you may not have cause, and that may be the end of it. Secondly, do what Mr. Justice Finlayson suggested, contextualize your evidence. Bring out and induce evidence suggesting not only what the nature of the misconduct was, but the impact it had in your organization, the particular corporate culture that it was pertinent to. And the third thing that I've done with success from time to time, at least it creates an arguable case that reduces gives the companies enhanced leverage during the negotiations, is essentially couple a warning with notice. And what I mean by that is give a warning in the normal course and then say, this is to advise you that you were terminated effective 8 months. We'll monitor you during that period. If you improve, we'll reconsider our position. For now, take this as working notice. And so during the period of time, the employee who may be trying to improve is working away arguably their severance pay. Now, is the court going to say ultimately there's too much uncertainty and that's not real notice, it's not sufficiently unequivocal? What I'm seeing in that area of law right now is the courts are requiring a lesser extent of unequivocality, if I can put it that way, in notice period than they once did. And I think even if they don't find that that's notice, they'll look at it as a factor to reduce the ultimate notice period provided. But the important point is, even if it's not notice, it might be notice, and that gives you some real negotiating leverage during the currency of the wrongful dismissal action.
Would that mean a good faith test?
Oh. Depends on the circumstances. Was it done in good faith? Karen? Nothing, except for perhaps an argument, and I've heard it made and I've not seen it adjudicated upon, that the fact of the disability policies themselves contemplating a long-term disability imported into the employment relationship means that the long-term disability is contemplated, and therefore the fact of long-term disability is no longer the fundamental repudiation of the employment relationship that it might be without the LTD policy. That would be the argument that one would use. And I don't think that argument would succeed, but who knows?
Do you still have your question?
Oh.
Actually, I was just, I wanted to ask Howard to expand a little bit on the again, nightmare scenario. Because correctly identified the problem that most of us group policies have, which is that they provide, at least complaining, that the policy covers termination of employee. And as you say, some accommodations can be made, whether it's a salary continuation or a relatively short-term immigration practice. But what do you do? What when you're counseling your clients where you've got a long-term employee who's executive nature, who's looking at maybe a notice period of 20 to 24 months on a reasonable basis, and there's no way you're going to be able to control your company into extending the LTD for that length of time? Like what advice are you providing?
And I take it that what you're saying is his employee is ill or in poor health so that it's a problem, as a practical matter.
Well, they're 50 or 55, but
I guess the answer might be you're effectively self-insuring, but I'm saying that advisedly. If it's a real risk, I guess it's always a risk as you put it, but if it's a real risk, what you would obviously have to do if you can't control your insurer and do extending benefit coverage is to offer more severance to get that release signed. And that would be a factor you'd have to take into consideration how much you ultimately offer, because that becomes a risk. Now remember, on the other hand, if they're 55 and we're not talking about death, we're talking about disability, disability coverage, which is at a reduced rate in any event and doesn't escalate with inflation, can only go on at longest to age 65. So there's a bit of a trade-off there with respect to the age factor. Yes?
Are we done with the comments earlier about suspension of the notice period during the period of disability? What happens if you had, for example, an employee who was suffering from alcoholism to the point that it was either absenteeism or so disruptive that it didn't matter the cause, but as of the date when you want to terminate him, he would qualify for disability. Does your right to terminate for cause, is it suspended until during the period of disability in the same way your notice period is suspended, or since it's cause, you can terminate immediately?
I think it's a difficult question. I think if you have cause in an alcohol situation, the employee hasn't applied for disability, isn't on disability, then you'll be fine. Now the question is, do you have cause? Because alcohol may be a defense depending upon the circumstance. And there's a number of cases in the alcohol and drug abuse area where what might be cause otherwise is no longer cause because of that particular defense, particularly if it's been condoned. Particularly, there was one case where it was a sales organization and the company had effectively picked up all the tab for the employees to take their clients out drinking from time to time. And then the court said you can hardly now rely upon this as a defense when you've encouraged these employees over the years to engage in convivial pursuits, as the court put it. But in any event, if you have cause, I think you're fine. Your concern would be if the employee applies for disability first. It might be a bit of a race.
What about the obligation to draw the employee's attention to his right to disability? You have
That's a tough.
You're required to do that, and if he does apply, will any of it be suspended?
It's a tough question, but how often are employees with alcohol problems really entitled to disability benefits on a long-term basis? It's certainly not a problem that arises very often. Certainly the courts are beginning to find the kinds of duties in the employment relationship that I think would import an obligation to advise an employee of the right to claim disability, but I really question or query whether the situation you're talking about would qualify for disability payments in any event.
Because alcoholism would be recognized as a ground for disability.
Well, because alcoholism generally hasn't been found to be, the nature of the disease isn't such that it creates a permanent disability from working.
But you raise when you're saying the degree of risk, you're saying not only the disability payments, but you might also be at risk for life insurance payments.
Well, only if there's not cause. If there's, now you're talking about potentially dying for whatever reason as a result of the alcohol down the line. If there's cause, you can terminate and you need not worry about any of this. I took your first question to be what if they were disabled at the time of the termination. Now that's a more difficult question, but I'm not sure that the situation with positive alcoholism would qualify as a disability in any event, preventing them from working, because that isn't what life experience generally is with alcoholics. I think there was.
If I can just say, our next speaker also is going to be, I believe, discussing the human rights legislation and query whether or not alcoholism would be considered a disability under that legislation and result in potential reinstatement.
There seem to be a lot of questions. I'll take two more, and then we'll go to Mr. Juriansz. Perhaps we'll have more questions at the end of the day, and Constance can remain for that as well. Yes?
I'm just wondering if you can get around, not too easy to be possible, but if you can get around the company's liability to disability payments or life insurance in the event of death during the reasonable notice period by keeping the person on salary continuance as opposed to providing a lump sum severance payment. Because when you keep the person on salary continuance, presumably there is an implication of a non-severed employment relationship, and you're
problem is, the question is, if you keep them on salary continuums, can you avoid this problem? And the answer is not according to most insurance policies that require the employee to be actively at work. Is the point being, if they're not actively at work, how can they judge when they become disabled? So the disability issue is a bit of a fiction from the standpoint of an insurance company that needs real objective criteria with an employee that's not working. But that's a function of the particular insurance policy. Yes?
Disruptive employee, what happens where there are allegations of an employee being disruptive? The employee is dishonest about it. The employee supposedly says something. Makes a couple of jokes about the manager. Get back to the manager, make no jokes about the employee says, for me, no, for me. And then the evidence is that yes, it wasn't, he was dishonest and lied. The manager says, we're firing you because you were dishonest, not because you made a joke. Would that be a cause? Well, there's an act of dishonesty, something minor, dishonesty, yes.
Well, you answered it yourself. I mean, it is dishonesty. Whether or not it's dishonesty sufficient to justify a cause would depend upon the case law. I've not encountered any cases that would substantiate dismissal on that act. That act doesn't seem significant enough. A continuation of that act, or several of them, or combined with others, would give more justification. But that individual one, I would be very uncomfortable in counseling an employer to terminate on that basis.
One act of dishonesty doesn't do it.
Well, dishonesty has a whole huge spectrum, as you can appreciate. Dishonesty in terms of did I give that joke or did I not, is not the same as dishonesty about an absolute lie as to I was here and I wasn't here, or I didn't take it and I did. So it's subjective. It's an interpretation to be given it. My interpretation is that is not sufficient, and I would suspect that would be the court's as well interpretation of that.
There was a case a couple of years ago where an employee went to meet a friend who they hadn't seen for a few years, and when they went back to work, the employer said, "Where are you?" And they said, "I went to my dentist." The employer found they weren't really at their dentist, and the court said, "So what?" Yes, it was dishonest, but in the scheme of things, it was of no moment, and it wasn't cause for discharge. So the duty of fidelity certainly has a significant component of honesty, but there has to be a smell test attached to it as well. Was there a real intent to deceive about anything that's relevant to the employment relationship? Then, of course, you get into the duty of fidelity cases and fiduciary duty cases with respect to any senior person where any act of dishonesty could be a revelation of character. The law is obviously fairly complicated in those areas, and you have to look at, to some extent, the status of the employee, the purpose of the intent to deceive. So, anyway, thank you very much, Constance. Russell Juriansz, who's joining me now, is a partner in the firm of Blake, Castles & Graydon, where he practices human rights law exclusively. He was called to the bar in 1974, and after 4 years in private practice, spent 10 years with the Federal Human Rights Commission. He was general counsel and director of legal services at that commission for 5 years in Ottawa. He's appeared on many of the leading cases in the area, including Roebuck, Binder, and O'Malley, and in fact, recently I've been reading about him in the newspapers in a large article in Toronto Light because he was appointed by Scotia McLeod to be its investigator on the recent allegations of anti-Semitism. That's not in the bio, but it was important. Recently, he represented the Federal Commission in the Women in Combat case, which resulted in all military trades and occupations in the Canadian Forces being open to women. He's taught human rights law and constitutional law at the University of Ottawa and administrative law at the Bar Admission course, and has written exclusively in the and extensively in the area of human rights law.
Thank you. Just following the discussion of absenteeism, I notice a short blurb in the back page of the Globe that Thursday afternoon has become the most common time for absenteeism. British researchers have found this, pushing Friday into second place. So I want to thank you all for still being here. And I too was quite impressed by the number of questions still being asked, but maybe by the time I get finished you'll all be asleep, hopefully. I'm going to talk about two things, the duty to accommodate and whether harassment might be cause for dismissal. And the duty to accommodate is statutory, and the tie-in to wrongful dismissal, I guess, is theoretically the possibility that an employment contract cannot be said to be frustrated due to the incapacity of the employee to perform his or her job if the employer hasn't fulfilled its statutory duty to accommodate. And perhaps we'll have a case where that's alleged. It may be that the court might defer to the Human Rights Commission and say that's a question that arises under the code, and it should be decided there. But let me read to you the section, at least in regard to disability. It's 17.2 of the Ontario Human Rights Code. The Commission, a Board of Inquiry, or court shall not find a person incapable of doing the job unless it is satisfied that the needs of the person cannot be accommodated without undue hardship on the person responsible for accommodating those needs, considering the cost, outside sources of fundings, if any, and health and safety requirements, if any. So that is the duty. Now, what does it mean? That is problematic. The code envisages regulations prescribing standards for what is undue, but there aren't any regulations. The government originally planned to have them, but I understand that the different ministries couldn't agree on draft regulations that were prepared, and the Commission, the Ontario Human Rights Commission, takes an extremely aggressive view of what is undue hardship. And the Commission doesn't use the word reasonable accommodation. The concept came from the United States and was first known as reasonable accommodation without undue hardship. The Commission doesn't use reasonable because in its view, undue hardship goes beyond what may be reasonable. And the Commission has issued guidelines. Let me read you what the standard is for cost. Undue hardship will be shown to exist if the financial costs, blah, 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 would alter the essential nature or would substantially affect the viability of the enterprise responsible for accommodation. And then further on, costs will amount to undue hardship if they are so substantial they would alter the essential nature of the enterprise, or so significant that they would substantially affect the viability of the enterprise. The viability of the enterprise. It sounds like a bankruptcy test, and especially with large employers, they could almost never demonstrate undue hardship on that test when they're dealing with an individual, because they can always hire an additional employee to do the disabled employee's work and still remain viable. So it's a fairly aggressive test. The Supreme Court of Canada very recently in Renaud and Central Okanagan School District, this is a judgment released on the 24th of September 1992, discussed the duty to accommodate and indicated that the standard was one of reasonableness. And Mr. Justice Sopinka, writing for the court, said that the use of the term undue infers that some hardship is acceptable, but it is only undue hardship that satisfies this test. The extent to which the discriminator must go to accommodate is limited by the words reasonable and short of undue hardship. These are not independent criteria, but are alternate ways of expressing the same concept. What constitutes reasonable measures is a question of fact, excuse me, and will vary with the circumstances of the case. Now, this case is a British Columbia case. It doesn't deal with the Ontario Human Rights Code, which doesn't have the word reasonable in it. And it's a little bit early to say whether the Ontario Human Rights Commission will adopt a less aggressive position because of the Renaud decision. The Supreme Court did indicate a list of factors that might be considered: financial cost, disruption of a collective agreement, problems of morale of other employees, interchangeability of workforce and facilities, size of the employer's operation, and safety. And when you're dealing with safety, the magnitude of the risk and the identity of those who bear the risk would be relevant as well. Sorry. There's also been a recent decision of an Ontario Board of Inquiry, Bonner, and the Ministry of Health earlier this year, which interpreted the duty to accommodate in a much less aggressive way than the Commission asserts. And it ruled that accommodation does not mean lowering minimum requirements of the position, nor does it mean accepting employees who are unable to do their job for substantial periods of time, simply because the employer has the resources to absorb the costs associated with doing that. But that's about all we know about undue hardship. It's even though the concept has been in the law for almost a decade, both first being recognized by the court and then being put into the code and amendments, the human rights process is so slow that there isn't a body of jurisprudence defining the term as yet. The other subject that I wanted to talk about was harassment. And harassment is an important social initiative, and it's got a lot of publicity. The human rights jurisprudence is fairly mature. It's clear there are two types of harassment: quid pro quo harassment, in which job security, benefits, or promotion are offered in exchange for sexual favors, and also poisoned environment harassment, where there is no making submission of a sexual nature a term of employment, but there's the subjection to a working environment that is intimidating, hostile, or otherwise offensive. And racial harassment cases are poisoned environment cases. And there have been all kinds of human rights cases in this area. What is new is the other side of the coin. Employers now are eager to provide workplaces that are free of harassment. It seems to me that employers are totally on board with the concepts and wish to ensure that no harassment takes place by their employees. So often, somebody who is guilty of harassment is fired and then turns around and sues for wrongful dismissal. And in my paper, I review some of these very recent cases. And I'm not going to go through the cases, but what is becoming apparent is that whether conduct constitutes harassment under the code and therefore would lead to liability on the part of the employer, and whether conduct justifies termination are two very different questions. The major, I'll just take a moment to list some of the distinctions. The first is pivotal. I think the very same evidence, the very same witnesses and other evidence will be assessed differently in a human rights case and in a wrongful dismissal case. In human rights cases, I have difficulty thinking of cases where a female complainant has not been believed by a board of inquiry, where it's her word against the alleged harassers. Yet in the Brick case, one of the cases discussed in the paper, there were two witnesses to alleged behavior, and yet the court would not conclude that the behavior had been established. And it is, I think, because in wrongful dismissal, you're dealing with someone's employment, and while theoretically the test is the burden of proof, the standard of proof is the same, it's a civil burden, the courts require pretty good evidence before they're going to take somebody's job away. Another difference is that in the human rights cases, the test of what is harassment is objective. That is, both the harasser and the harassee's perception will be subjected to a reasonableness test. There's so many cases where the guy was just a knucklehead and couldn't understand how offensive he was. He really thought he was being cool. And in human rights cases, too bad. A reasonable person would have known that your behavior was not in accordance with what is seen as socially acceptable. The early cases in the wrongful dismissal area haven't articulated that distinction clearly. They seem to look at it from the harasser's point of view, and one of the cases talks about, well, he did this, but he was oblivious that he was making people uncomfortable. And they didn't go on to address the issue of whether he ought to have known that he was making people uncomfortable. In the human rights area, it's very clear that a complainant need not protest before having a valid human rights complaint, need not say to the guy, you know, you're bugging me, or you're making me uncomfortable, or I protest your behavior in some way. Yet in these early wrongful dismissal cases, one theme that comes back in several of them is that well, maybe he did that, but she never told him that it bothered her, or they never told him that it bothered them, and so that the courts are commenting on the lack of protest and seeming to require a very clear protest before saying there's just cause for dismissal. Persistence after a protest. And in the Shields case, which is in the paper, the court found there had been an outright sexual advance. And the woman had said no, but he didn't make another advance after that. So I think that one, there's some common ground between human rights cases and wrongful dismissal cases, because in both cases, it's important for the employer to have a very clear policy on sexual harassment, because then the employee is on notice as to what the standard of expected and accepted behavior will be. And again, in some of the cases, a warning to the employee as to what is expected and accepted is seen as something that the courts would like to see before saying that dismissal is justified. And the last one I'm going to enjoy talking about, because anybody who does human rights cases is quite horrified about how slowly the Human Rights Commission works. And certainly an employer can find out there's a human rights complaint against it, perhaps a harassment complaint, long after the employee has left. And no matter how old the complaint is, the Human Rights Commission will proceed with it, and I think it would be unusual to deal with a complaint, the facts of a complaint, in under 6 or 7 years. But the courts in the wrongful dismissal area have hinted that there's a need for prompt action, and the Wackenhut case was mentioned earlier, and some of the behavior alleged there included offensive language that might constitute harassment under the code, and the court found that there was condemnation because there was no prompt action. One of the other cases also remarks on that. So I don't want to give the impression that the courts are not supportive to employers who are taking aggressive action to make sure that there isn't any harassment in their workplaces, because there are decisions that go the other way, and they're discussed in the paper. It's just that there's so few cases in this area. The jurisprudence is still uneven, and these are just my impressions of some of the standards which are emerging.
I guess, Russell, it's the contrast between the procedural protections the courts have given people who are terminated before they find there to be a cause for discharge, and on the other hand, the Human Rights Commission's mandate to stamp out harassment and discrimination. That's probably the reasons for the different set of standards so far. That's just my reaction. I have a couple questions just before I turn it over. There's a reference in your paper, I noticed, in the Shields case to the fact that the court said the plaintiff should have been given an opportunity to respond to the allegations. What if clearly there's sexual harassment occurring, that's established at trial, the woman who's harassed comes to the employer, asks for confidentiality, advises them of what's occurred, and that's very common, and the company terminates the employee because of sexual harassment but doesn't specify anything more than that. And at trial, it's established that there was sexual harassment, it was unwanted, it was persistent, all of the requisite steps, and it's clearly cause for discharge. Might the plaintiff win because they weren't given an opportunity to respond before being terminated?
Well, I'm not a wrongful dismissal expert. This is a question I'd like to ask you.
I wouldn't think so, but I'm looking at your comment on the Shields case.
Well, that's what the judge made a comment in that case and about the procedure. The facts were that a woman had made certain allegations, and the employer interviewed her, was satisfied she was telling the truth, and then took action against the guy. He didn't have the same opportunity to convince the employer that it should believe his side of the story. Later on, he started dealing with the employer through a lawyer, and the court said, well, at that point, if he wanted to tell a story, that could have been arranged, but he never tried, and so he can't raise that now. So I was listening with interest to the discussion about procedures, and it's hard to put that together with cases who say you can justify termination with after acquired evidence and everything else. So I'd be interested in your comments.
Well, My view is that the procedure isn't important. There was some early cases, particularly out of Nova Scotia, where there seemed to be an obligation to give a chance to respond, but that seems to not be the law anywhere else, and perhaps not even any longer in Nova Scotia.
You know, it's interesting because I think sexual harassment is so controversial because it affects people so deeply that it can give rise to new principles in the human rights area with delay. The courts of appeal in Manitoba and in Saskatchewan have carved out special recognition for delay in harassment cases as opposed to other cases because of the special impact harassment cases have on the reputation of the respondent. And so where they may not prohibit a board of inquiry from proceeding in any other human rights case, they give these orders in sexual harassment cases. And I think there may be some special concern for procedures used in a harassment situation.
It may be, I've noticed in other areas of wrongful dismissal law, particularly regarding public employees or quasi-public employees and probationary employees who otherwise have less protection because of some administrative law concepts that are pertinent to those. The courts are importing those administrative law concepts and requiring more procedural protection than for regular permanent employees. So that might be the case. Again, the human rights issues administratively infiltrating into wrongful dismissal law. My other question to you is, I think the name of the case is Levitt, if you're familiar with it. I saw it recently, and it seemed to find that a rather abusive male, but he was abusive to everyone, but to a particular female complainant who he was particularly abusive to, he referred to her, I think, as a fat cow, or something like that, and the court or the Board of Inquiry said, that's a gender-laden expression. And therefore, it's violative of the Human Rights Code, because the argument was, yes, I was abusive, but it had nothing to do with any prohibited ground, and it wasn't related to her sex. I just didn't like her. And the Board of Inquiry, as I recall the case, said that, well, calling her a fat cow and referring to her unattractive appearance is gender-laden, and therefore it is a violation, it is discrimination based on sex. Now, to what extent might one anticipate that type of a ruling?
In the human rights context?
Yes, in the human rights context.
One could anticipate that type of ruling, yes. One could anticipate it as a certainty. I think that while the poison environment theory that developed in the United States originally meant that the comments and the behavior had to be so pervasive that it constituted the working environment. But the way the Ontario Human Rights Commission is dealing with that concept is to take one comment, one or two comments, and that's it. You've affected a person's working environment.
Let me open up to other questions to Russell. Yes.
Yes, on the duty to accommodate issue, prior to the current legislative duty to accommodate that's now in Section 17 of the Human Rights Act, prior to that, was there a common law duty to accommodate if there was Section 17 of your codification, or was that different?
Yeah, well, the duty to accommodate was recognized by the Supreme Court of Canada in the O'Malley and Simpson-Sears case without any statutory support whatsoever. And the court recognized that there was no statutory support, but said that the code accords the right to be free from discrimination in employment, where, while no right can be regarded as absolute, a natural correlative to the recognition of a right must be the social acceptance of a general duty to respect and to act within reason to protect it. So it was on that reasoning that the court plucked out of the American jurisprudence the duty to accommodate and said there's a duty to take such steps as may be reasonable to accommodate the employee without undue interference in the operation of the employer's business and without undue expense to the employer. After that, the duty was put into the code, but it simply said accommodate without a undue hardship.
Yes?
Can you repeat the citing of the word inquiry that you mentioned at the outset regarding duty to accommodate?
Bonner and the Ministry of Health. It was decided in February of this year. It may be reported now. I'm still carrying around an unreported version.
Yes?
Yeah, just a question with regards to the poisoned environment concept. There's a different environment in different workplaces. There's a certain liberality of language in a police station, perhaps, as opposed to municipal office or whatever. And my question is, if the general environment is perhaps more liberal in terms of the nature of the language and so on, does this relate to the poisoned environment? In other words, through a different standard, could an employee who basically was behaving in the same fashion as other employees in the general atmosphere of the office could find himself falling not on the human rights complaint, but in terms of dismissal? In
No.
other words, could he be dismissed for creating that poisoned environment or harassment as easily in an environment where the language is perhaps familiar?
Yeah. Well, let me first comment on the human rights context. The human rights cases have discussed a flexible standard that is based on what is usually accepted in the particular working environment. And according to that, if the working environment usually tolerates offensive language, then the language has to be extra offensive before you've got a harassment case. I don't think that reasoning is sound, because it may be that working environments in which most of the employees are male might have standards which make it difficult for female employees to get into and to succeed in, so that the usual standards may be a discriminatory barrier. So that's in the human rights context. In the wrongful dismissal context, based on the few cases that there are, I would say that the usual standards in the workplace are relevant in determining whether there should be discipline for behavior. The courts have indicated that the person has to understand that their behavior is making people feel uncomfortable, and there should be a protest. And after the protest, if there's a persistence, then you've got a situation where discipline could be imposed, approaching termination.
Certainly in the paper today, or the lecture today from Mr. Justice Finlayson, and in the paper today from Nancy Courtney, the contextualization of cause was emphasized. So there are different standards, and that's particularly notable in the last 2 or 3 years of case law.
If you have a situation where an employee is being harassed because of their religion, sex, or sexual preference, they complain to management, and the employee is not satisfied with the response, there are some measures taken to reprimand, maybe something less than dismissal. Number one, does the employee go before does the employee have a choice? The employee is making a position of constructive dismissal. Does he or she have a choice of choosing the human rights code or the common law courts? And number two, assuming, I think it was Simon Israel's case, it happened in Canada, where do you have a better chance of success because you weren't happy that management just reprimanded and didn't fire? Would the human rights code act on that as opposed to the courts? Where would you advise an employee of where to go? Do you have a choice?
Well, there are lots of considerations that might be put in it depending on the particular facts of the case, but generally speaking, it's far more certain that allegations will be found to be substantiated in the human rights context. Both the quality of the evidence and the actual behavior themselves, the facts of the behavior themselves. So that, and one isn't forced to make a choice between going to the Human Rights Commission or suing for constructive dismissal. One can do both. It may be that the constructive dismissal action will be stayed until the human rights complaint is dealt with, but you're not forced to make an election.
Can you be arguing to go by the common law, human rights, practice the code, and practice code? There is that argument, then there is law, you know.
Well, that argument is insurmountable in the human rights area because of the Supreme Court of Canada decision in Bedari and Seneca College. If the action is founded on something that is covered by the code, you cannot sue civilly. And even if it's something that's embodied in the policy of the code, the Supreme Court of Canada went on to say in that decision. So it's very, very broad, and probably it's a more clear argument there than anywhere else.
Well, the Bedoria case dealt with somebody who was applying for a job, and there is no duty apart from the code not to, to choose somebody for employment without reference to the prohibited grounds. At the same time as the Bedoria case was before the Ontario Court of Appeal, there was another case which was a termination case in which the person sued for wrongful dismissal, and the termination would have been discriminatory. And the Court of Appeal allowed that case to go ahead. I don't have the cite for it here, but the Bedoria is good law, but a termination may be wrongful and be discriminatory.
That's right.
Yeah. Pardon me?
Well, I just want to make the distinction in Bedoria. You can sue for wrongful dismissal, and it may happen to be discriminatory, but you're suing still for the wrongful dismissal, as opposed to a Bedoria situation. Just to make clear what I'm talking about, if you can't sue civilly for sexual harassment because that's a right provided by the code. You can't sue civilly for not being hired by reason of race, creed, color, 'cause that's a right founded on the code. You could sue for wrongful dismissal even though it may happen to be that you were dismissed for reasons of discrimination. But that's not what you're suing for. You're suing for the act of wrongful dismissal. And perhaps you may get punitive damages because of the circumstances being violative of the statute.
It takes me back to the employee takes a position of constructive termination because he's not happy with the measures taken by management.
Yes. Okay. But
How do you see that happening in the common law?
You're suing for constructive dismissal then, and it may happen to be that there's discriminatory overtones.
He's saying sexual harassment.
Oh.
it,
Happens to many people, visible minorities, gays, and what have you. They're not happy with the responses taken by management after they complain. They're still uncomfortable in the environment.
it'd be difficult to use a human rights complaint to force an employer to take penal action or impose discipline for a couple of reasons. Under the code, there is authority for a board to make an order that a person who has the authority to discipline or sanction behavior do so. But that authority only is invested in the board after a finding of harassment and where there's a continuation of the behavior. So if it was a one-time or the first-time complaint and the employer put a stop to the behavior, it didn't continue, going to the Human Rights Commission would not enable the employee to force the employer to impose additional penalties unless there was a continuation of the behavior or a reoccurrence of the behavior.
What about on the civil side?
Is that the question? Sorry, maybe maybe I've lost the question.
On the civil side, if you sue for common law, they have constructively said because you don't feel management took severe enough measures.
Okay. What's the actual question? I think I've lost the question.
The question is, how do you see a court handling that in terms of the courts often allows management certain discretion, not disciplinary measures, and then you have the human rights policy of the province. Do you understand my question?
I'm not sure, but let me answer what I
Well,
think the question
Howard,
is.
I think the question is, could the plaintiff substantiate constructive dismissal because it was displeased with the way management dealt with whatever the discrimination was?
Well, I'm not sure that from my employment law or wrongful dismissal construct, I don't see the question that way. You have constructive dismissal because of the objective conditions in the workplace. If management had acted differently, there might be different objective conditions. You can't found a constructive dismissal case on the fact that management didn't act appropriately. You found a constructive dismissal case on the objective abuse or otherwise, the objective repudiation of the terms of employment experienced by the employee, him or herself, not on whether or not management took action appropriately. Whether or not management took action appropriately would obviously impact on the conditions the employee faced.
Yeah, I've seen the situation you're talking about, a rise in sexual harassment cases where a complaint is made and the employer takes action but doesn't terminate the harasser. And then the victim says, even though he doesn't talk to me anymore, and even though he doesn't harass me anymore, just seeing him at work or walking by his office makes me feel uncomfortable, and therefore I can't work here anymore. Is that...
That is not the sort of case the courts have very much sympathy to in the current regime of constructive dismissal, if that's the question. Let's take two more questions, and then we'll call it a day. Yes? No, I didn't say that. I said that if an employee is terminated without cause, severance doesn't begin while they're disabled. For example, if someone is terminated and they're disabled at the time of termination, and they're disabled totally disabled for 3 months, in other words, unable to look for work, and reasonable notice is 6 months, the court will give them their short-term disability payments for 3 months, and then notice will commence beyond that date. So they'll get a total of 9 months. Immediately. However, that may not, it would be arguable depending upon the terms of the benefit plan whether they wouldn't continue receiving disability benefits, although I think they would not, because it would be repudiation of the entire relationship, including the disability benefits. But that matter could be argued. I think there may be an issue as to whether or not the disability benefits, whichever they are, is a collateral contract. And to that extent, the termination for cause may not, and I don't think this is right, I'm just simply speculating, may not terminate the benefits. But my view is the benefits would be terminated because the entire employment relationship and all of its condiments would be terminated by the act of cause. Yes?
Picking up on that point, would the notice period similarly be suspended if your long-term disability contract is such that it did not require that an employee or an individual continue to be an employee in order to receive the long-term disability benefits as long as the incident that gave rise to the disability occurred while the person was still an employee, thereby sort of vesting the right to long-term disability. That's the nature of your long-term disability contract. Would that similarly suspend the notice period?
I'm sorry. If the employee was, when was the employee terminated? During disability? And it was without cause termination?
That's right. You want to give notice, reasonable notice of termination. The employee is disabled. It looks
Yes.
like perhaps they're going to be permanently disabled, but their right to the long-term disability benefits is not predicated on their continuing as an employee, but the notice period will still be suspended. It seems to me to be suspended in perpetuity.
Well, I think it would be, except the answer to that question is if they're indefinitely disabled, quasi-permanently disabled, it's a frustration of the employment contract. And the best answer, the best law appears to be at this point, although for the reasons given to a question about 30 questions ago, this is arguable, the benefits would cease and everything would cease at that point. If there's a termination with cause, that would be the end of it. If the termination without cause, the benefits would continue, although the employment relationship would be at an end, and therefore, A, there'd be no notice after the disability period expired, and B, there'd be no right to return to employment, which is the real issue in most cases, because there'd be a termination of the employment.
I understand that. That was a no-cause situation. It's not a reasonable notice requirement at the end of the
Well, the cause would be the permanent disability.
Frustration.
Suspended until you have that kind of a definite
I mean,
diagnosis.
we've been talking, just to clear up the confusion, we've been talking about what happens in an absence of cause in a disability situation. Let's not lose track of the fact that if we're talking about quasi-permanent disability, that in itself is a frustration of the employment contract. So if an employee is essentially totally disabled and will be for a very long period, maybe permanently, at least for a few years, that ends the employment relationship. It doesn't, as a matter of frustration of the employment contract. It doesn't end the right to claim disability benefits, which is precisely what the disability policy contemplates, but it terminates their employment, and two consequences flow from that. One, they don't get any notice ever, because it's a with-cause termination because of the disability, and secondly, when the disability ends, they can't return to their job because they've been terminated.
The theory is that where there's a valid employment contract, the employer has to give reasonable notice of termination. Where an employee becomes so disabled that they are unable to perform his or her job, the employer doesn't need to terminate the contract. The contract is at an end because it's frustrated. It's like as if the workplace burnt down and there's no place to go to work anymore. And so it's not terminated by the employer. It's just at an end because it's been frustrated, and therefore no reasonable notice period must be given.
I think where I may have confused you, when I answered this gentleman, I asked him the question, are you referring to a without cause termination? I simply was trying to distinguish that from a situation where the employee was terminated for theft or something, because I was going to deal with separately. In fact, there was cause when it's as long-term as that, because it's frustrated, which is one of the categories of cause.
And Howard, there's just further confusion in that there is no definition of what long-term disability is. So an employer may incorrectly assert that someone is disabled on a long-term basis, and a court may conclude that it's not.
The English Court of Appeals given the best definition, and that is as vague as when the employee is disabled for such a long period of time in terms of their history and character of their employment that it's not reasonable to maintain them any longer as an employee. That's the best definition I've seen. Listen, if anyone wants to ask us questions privately, please feel free to do so. Otherwise, thank you to those of you who are still here for remaining this long.